You're watching The Luke Bryan Show.
Luke, you've been involved in disability, and you've done a number of decisions, and most recently you have a Court of Appeal decision called Gascoigne.
Yeah.
Why don't you talk a little bit about disability law generally, and a little bit about that decision and the significance of the test that came out of that decision and what it's done to disability law?
Yeah, so in terms of disability law, the law is essentially, people are, if they have a disease or an illness and end up on long-term disability, often through their employer, sometimes those disability providers will terminate the contract and stop paying them for whatever reason. And they, a lot of insurers do it, and often the reason for termination is not valid. And often that person almost always is in a very vulnerable position. They are so sick they need to be on disability, they're not collecting a paycheck, and then their disability is cut off. And so they tend to be in a very, very difficult position financially, and just providing the basic data needs. And in the case that we ran to trial, it was our client had kids at home and really was not able, or was really struggling to provide even food for her kids and shelter. So that was very compelling in terms of the background facts. But so the disability provider cut her off and said essentially that her injury was not something that she should be disabled from, and she should be able to return to the workforce, and she was not able to. And we were able to prove that at trial and have her disability benefits reinstated, which is one of the kind of ties into what we tried to do at the Court of Appeal, which was change the law. So the law historically in disability context has been, if you go to trial, they essentially give you your back pay up to the date of trial, and then they put you back on disability and with the provider. And it's an odd way to approach,
especially when the provider is the one that cut you off.
Exactly.
And didn't have any legitimate reason to do it.
Yeah, and it's especially when it's been done in bad faith, and so in there's no other contractual context that I'm aware of that happens, where someone breaches the contract with bad faith, and the court says, okay, go back to being in that contract together.
And there's no reason the very next day the insurance provider can't just cut them off again and breach them the same as they had before.
And so I saw that as a hole in law and something that's quite unjust, and so was successful on the basic argument of getting her reinstated at trial, and then I wanted to change the law on the area about the future of disability payments, and suggested to the Court of Appeal that it should be a payout of some sort rather than putting them back on claim.
And so historically, it was never a possibility. There was no mechanism for the court to allow them to pay out the future of the claim. They would just put them back on. And in your case, you actually managed to get a test put in place for the first time since the Magna Carta, where they managed to set up the criteria to say, if you meet these criteria, then we'll pay out the future of the claim.
Yeah, and then that has not happened in Canada, at least that I'm aware of, where that has occurred. So there is I think now a legal test that can be relied on to potentially pay out the entirety of the claim, and still that's not necessarily an easy road to go down, but it is something that I think is, well, just really unjust the way the law was, and that ties into I think our passion for doing law is really protecting people and making sure they're taken care of when they're vulnerable.
Yeah.
So in terms of like a disability case, if a person is terminated on their disability from their disability contract, the big thing is to call a lawyer. We do a lot of this work on contingency, so you're not going to be paying out of pocket, and it's something that we can give you advice on, and consultation is free. So it's you pick up the phone, we'll talk to you and tell you what your rights are and whether you have a case to advance or not.
And why do you take these cases on contingency? What's the sort of driving force behind the contingency, and why you don't demand a large retainer and charge them hourly?
Yeah, contingency is, in our society, we have an issue with access to justice, and justice is expensive. And there's some scholars that write, justice is only for the wealthy. Legal scholars are writing about that, and there is some truth to that. But contingency agreements are a way to flip that. So it is, there's a payment out of the total settlement as opposed to, traditional retainer and hourly billing. So, which is, often creates just an access to justice issue because people can't pay that retainer or the hourly fees. So it is something that we do a lot of work on contingency, and it's something that gives people that access to justice.
Yeah, because in the case that you were talking about in the Gascoigne case, I mean, you'd said that obviously they were cut off, and that was their only means of money. They're not working.
Exactly,
their only means
yeah.
of money was the insurance provider, and the insurance provider stopped paying them, so they have no money. And so without this type of agreement, there wouldn't be any real basis to access justice.
Absolutely, yeah. So one of the areas that you practice a lot in is employment law, and so maybe tell us a bit about employment law and maybe a bit about your why, and then some of the technical aspects of employment law.
So employment law spans all matters of employment. So a typical situation is when an employer hires an employee, right? And so that creates a contract. Often contracts are written down, but sometimes they're inferred. If you go working for somebody and they say they're going to pay you $20 an hour and you're working Monday to Friday and you don't have a piece of paper saying that, you still have a contract. And the terms are set out by the sort of agreement by the parties that it's carrying on. And so what happens is while you're an employee, you have rights. There's things that an employer is allowed to do and things that they're not allowed to do. And often what employment law, and I think the vast majority of why lawyers get involved, is people are terminated without cause and without proper severance. And so when somebody is fired, there's essentially 3 stages of severance you can get. One is statutory, which is the employment standards, and that's roughly 1 week per year and caps out around 8 weeks. And then that's we call it the floor, not the ceiling. So that's the least amount you can get, and no contract or agreement can deprive you of those minimums. And then there's contractual severance. And so contractual severance has to be at least employment standards minimum, so it can't be less than that, but it can certainly be more than that or the same as that, and can limit you to the employment standards minimums. And then there's the common law severance. So the common law is what the jurisprudence has come forward, and they've developed a list of factors called the Bardell factors. And when you assess those factors, they kind of come to a different number. And generally, it is substantially higher than the employment standards amounts. And so if there's no contract limiting your severance and you've been terminated without cause, you generally have a right to receive a substantial amount of money, or substantially more than what the employment standards are. And that's why lawyers get involved. And really, the reason that we do it is to, again, help the little guy. I mean, it's a situation where people are left without money. They have no job. They generally don't have a lot of recourse. Sometimes the employer will say that they've quit or that they were terminated for just cause. And in those situations, sometimes you certainly if you quit, or if the employer says you quit, you won't have access to employment insurance or EI, and people don't have money, or they haven't been working long enough or whatever. And so you have a situation where somebody's trying to look for work but can't find it, and they've got mouths to feed and a family, and they just don't have any money to pay for a lawyer and have that access to justice. And so that's something that we step in and say, hey, we can help you with this and get you what you're entitled to.
And often employers will give a letter when they terminate to the employee, and it'll say, hey, here's our severance offer, and you need to respond in 3 days or 5 days or whatever. And if you don't respond, your claim's gone or something like that. And they put this pressure on. Is that real, or tell us a bit about that?
Yeah, so the deadlines are real. I mean, they can revoke it after that, but the reality is that you've got 2 years from the time of termination to commence a claim. So if you're not happy with the severance package and you don't think it's enough, or you don't have enough time to review it, there's very little risk in not accepting the offer, because you can always just bring a claim for what you're actually entitled to. And generally speaking, employers are offering that amount of money because they want to button this up and get you to sign some sort of release. It's generally in exchange for you signing a document saying that you're not going to sue them. And so they're generally quite willing to put that back on the table if it ends up being a fair offer. But yeah, so I'd say, yeah, there can be some risk, but the reality is that it's negligible, and you have 2 years to bring a claim forward. Okay.
And there are some different limitation periods for human rights claims, or
yeah, for sure, well. Definitely, yeah. So human rights is 1 year, and so that's a situation where somebody discriminates against you on the basis of a protected ground, usually race, family, gender, those types of things.
Disability.
Disability, absolutely, yeah. So you're not able to do your job because you're injured on the work site or something, and they terminate you, it can definitely raise a human rights issue or discrimination issue, and that's separate from the severance or the wrongful dismissal claim.
And a lot of times the employers will say you're being terminated for cause. I mean, is cause hard to make it? Like, what is cause, and is it hard to make out for the employer?
Yeah, generally speaking, cause is very difficult to make out. So for cause versus, there's only two ways anyone can be terminated, right? There's for cause and without cause, right? So either they have just cause to terminate you, meaning that you've done something of a substantial nature that warrants immediate termination without any severance or any compensation. And then there's without cause, meaning that no employer is required to stay in a relationship with an employee that for whatever reason. I mean, whether they're downsizing or they're not working hard enough or whatever. But just because an employee is a bad employee doesn't mean that it's just cause for termination generally, right? So so that's the without cause situation, in which case you're entitled to severance. But cause, to establish cause, it's really difficult. There's a case came out from the Supreme Court of Canada called McKinley, and it talked about progressive discipline. So in order to terminate somebody for cause, you generally need to have a bunch of progressive steps. So if they're late, you need to give them a warning, and then kind of give them another warning and
it's
another
like
warning.
Baseball, 3 strikes and you're out kind of thing.
Yeah, I mean, sometimes you don't need 3 strikes, but I mean that's sometimes you need more than 3 strikes. Yeah. But in baseball, certainly it's only 3 strikes. But it depends on what's happening, right? And some things are so severe that they do warrant immediate termination, and so and often those are set out in your contract. So if you're a heavy duty operator of machine and you're intoxicated on the workplace, that could be grounds for immediate termination. Or if you go in and steal a bunch of money from the safe, that can be grounds for immediate termination. But then there's some cases out there where people have stolen money and it hasn't been grounds for termination. So, it's very difficult to make out just cause. And so anytime your employer tells you that they're terminating you for cause, you should at least consult a lawyer for sure and see whether or not they had substantial grounds to do that or not. Luke, one of the areas that you practice in is commercial litigation. Why don't you talk a little bit about commercial litigation generally and what that entails? Yeah,
so I mean, it's an area both you and I practice in, and it's typically a commercial dispute involves often business people fighting about what's happened in the business. So often you're having a contractual dispute, and that can be a shareholder dispute. It can be any type of fight. It can be about the purchase or sale of a business. It can be, property disputes. There's a lot of those that we do deal with. So, and often, I'll talk about a case I did, a commercial dispute. This went to trial. It was the purchase of a blueberry farm, and my clients had purchased a blueberry farm, and the contract said there was a specific variety of blueberries, and it was, I think, 40 or 50 acres of the farm, and this specific variety was important because it produced the best crop, and it was tied specifically to the purchase price because of the value of the crop, and it was expected. And so
some blueberries are worth more than other blueberries.
Absolutely.
Not all blueberries are created equal.
They are not all the same. And so so we sued on the contract, and the difficulty with the contract is they hadn't put the variety of blueberries. They just said a blueberry farm. And so we had to sue in fraud, we sued in contract and in fraud. And so it ended up, I think, 15 acres of the 50 acres were a different variety that was not nearly as profitable in terms of the crop. And so we were able to establish at trial that the vendor who's selling the property had committed fraud by describing the variety of blueberries and lying about it to our client, and so we were successful in obtaining a judgment for our client for the difference in values of those two types of blueberry. So yeah, that's an example of a commercial dispute, but they come in all types of varieties and sizes, and you have multi-million-dollar disputes, you have $20,000 disputes, and so it's commercial litigation is tough on smaller disputes, but we can still guide people through those in the background, or explain how to go through small claims court or any of those types of things. You've done quite a large number of commercial disputes as well. Talk a bit about your experience in the area.
Yeah, so at its broadest sense, I mean, commercial disputes are any dispute between two commercial entities, right? And so it can go from shares, values of shares, buying out partners, to purchasing land and land falling apart, or the deals that the commercial entities strike between each other. Yeah, most of the disputes that I deal with are generally land purchases that have gone awry, shareholder disputes, and yeah, mostly contracts and debts and building, right? So often one commercial entity will hire another commercial entity to do some work, and they're not happy with the work, or they are happy with the work, but they're just refusing to pay, and those are situations that arise in the commercial landscape and are quite common. The value of those debts can be quite small, but they can also be quite large. And so, often they're hundreds of thousands of dollars, which certainly warrant getting a lawyer involved. And even on the lower end, something that we do is, we'll do a consultation and we'll guide you through that process and try and keep it economical and proportionate and deal with the matter. Ultimately, our goal is to try and help people and to create value. So, Luke, if somebody's involved in a slip and fall, what steps should they take at that point? So, from the time that they fall onwards.
Yeah, and so it's tough because often you get hurt, and sometimes people hit their head, or or they're embarrassed and they don't want to leave the area. But the important thing to do is preserve the evidence. So, take a picture of whatever you fell on. That's the most.
Somebody else take a picture.
Yeah, or find a witness and get their name and phone number, someone who saw it, and just say, hey, can I just get your name and phone number? And that's really important to preserve that evidence, because as the plaintiff in a slip and fall, you have to prove your case. It's your burden of proof, they call it in law. So what that means is, if you don't meet your burden, it could have happened, but you haven't proven it, you lose. And so there's two key components to a slip and fall case that you have to prove. One, that there was a hazard, and that hazard was unreasonable. And then two, that hazard actually contributed to you falling. So you could fall beside a hazard and it has nothing to do with it. You have to prove those two steps, both that there was a hazard that was not safe, unreasonable, they should have maintained their premises better, and secondly, that hazard was the cause of your fall. Sometimes people just fall. And so it's those two pieces that are critical to prove. Your footwear and then is important, but then the next big piece is to make sure you go to the doctor and see a health professional and talk about your injuries. And that creates a record on the injury side of what's occurred, and that record is absolutely critical to us in terms of, I often talk to clients about the records are the ammunition we need as lawyers to fight their case. And if I have no records, I have a gun with no bullets in it, and so it's like giving us those bullets so we can fight for you. Without those bullets, we have nothing. We have an empty gun and there's nothing to shoot at, right? So it's that evidence that's so critical in terms of building a successful slip and fall case.
And then how do they go about getting in contact with a lawyer, or how do you know whether they should get a lawyer or not get a lawyer? Yeah.
I mean, if you're injured and you've fallen, definitely we do free consultations for people in slip and falls. We do most of these cases on contingency, which means that you don't pay until the end, and we only pay a percentage of what we obtain for you. And so that really is, in a sense, we take on a substantial part of the risk in terms of advancing the slip and fall, because if we don't accomplish a result for you, we don't get paid. And so that is, and I mean, for us, we've done a lot of these, probably done hundreds of slip and falls, and we've seen every fact pattern imaginable. And the other part, a big part of what we do is we do use experts. And then we have an excellent engineer who helps us a lot on these types of cases. And, if it's warranted, he'll review the situation, write a report, and that can help a lot in terms of proving the case and getting a good outcome for the client. So one of the areas that you do a lot of, and was actually one of your first trial, and Brian won his first trial, and I told him, I remember I was like, he got reported in the national media and was being interviewed on the radio and on TV, and I was like, Brian, you should just quit law now. You've hit the high mark. You should have taken that advice. Your first case went to national news, and it was a defamation case, and so it's an area that you've done a few cases in and had quite a bit of success. And that Pritchard case was really interesting because it made new law in the area of internet defamation specifically, and such a burgeoning area because of all the changes to social media. And why don't you talk a bit about that case and defamation generally?
So defamation generally is really, anytime somebody says something bad about you that's not true, ends up being some form of defamation, and that's quite generalized. I mean, there's a lot of steps. I think defamation is probably the most complicated tort with the most amount of reverse onuses and things bouncing back and forth. But I mean, the reality is that there's two types of defamation. There's libel and there's slander. And so libel is the written word, and slander is the spoken word. And there's a bunch of exemptions and things that go on there, and defenses. And really, it's the battle between free speech and your charter right to say whatever you want, but then also somebody's right to not be defamed or disparaged unduly or unlawfully. And so it's the fight between those two rights and the case law that's developed based around that. And so I won't get into the specifics, but certainly if you feel that you've been defamed or somebody said something about you that isn't true and it's impacting your life, then you should certainly seek counsel to assist with whether or not that is something that you should explore, or whether or not you have a right to damages. One of the cases you mentioned that is called Pritchard versus Finesse. It was a case I did right out of articles, and it was my first trial on my own that I ran by myself. And prior to that, I had juniored a number of trials. But the case was a difficult case in the sense that the person we were suing didn't actually say all the words that we were wanting to. They sort of made some inferences, they kind of left things out there. So the actual words stated, you could draw inferences from them, but they weren't actually said by the person that we were suing. And so what happened was it was on Facebook, and all of the friends, or the Facebook friends from the defendant, did say all those things. So they made those leaps that we would expect. And so what I tried to do was tried to hold the defendant liable for each of the other comments posted by other people, as if she had made them herself. This was quite a novel law, and something that hadn't really been advanced, but there was some precedent for it in the in like the news reportings and stuff. So newspaper articles, historically, if there's the editor-in-chief, they're responsible for all of the columns that are written by the reporters. And so historically what happened was the court had held the newspaper company liable for columns written by the reporters in defamation. And so I tried to akin this on the sort of the social media platform to say, well, this Facebook page is essentially her column, her newspaper. And then each of the people writing there were reporters, and she had the power to delete them and not have them on there. And Justice Saunders agreed with me. And so we created new law and established a way for people to hold on social media anyways, on platforms like Facebook, where you have control over all of the comments on there, to hold them liable for all of the posts as if they posted them themselves. And so they created a test for that. And so, it was quite an interesting case. And I think that's why it got the media attention that it did, because it was one of the first social media cases and established some new law on holding the owner of the site liable for other people's comments.
You're watching The Luke Bryan Show.